10.3.
Between you two, who is elder?
I'm sorry.
Between you two,
That's
you
a
and
compliment
Mr.
to him, not a compliment to me.
by seniority, who is senior?
Mr. Senior, of course, he's
No, Manas, he is senior.
much more senior.
It makes no
Much more
difference.
senior.
It makes no difference.
Have you flashed it?
It will take his. It will take.
All it's starting. Who is appearing on behalf of Mr. Raju?
A few passover matters.
Wait. Also, last precedence.
Please, Manoj, I beg to appear for the Delhi police. Mr. Raju is on his way.
Oh, you are there?
He's on his way.
Wait, please.
Huh?
Just use the file.
Sorry, there's some bail matters was pending. Item 15. So also some bail matters.
We'll take it up. They'll finish it within 15-20 minutes.
Within, the Lordship said half an hour, we finished before that.
Yeah.
Before that. Now with this. So I'll just, well, I've missed the points which we are highlighting. I'm now, Lordship will use the file of item 10, because the files may be different. So, Melissa, I have a short note, but before that, let me just itemize the points I made. First point, obvious point, that I am in jail. I'm talking about item 10.
You have prepared a
Yes, I'm giving it.
list of it?
Yes,
Pass it on.
and you can do it. We are giving 2 copies, so we don't have any.
We'll take out advocate say. Yes.
The first respectful submission is that I am admittedly in jail for 5 years, 5 months as I speak now, which is from 11th of April 2020. The second point is, these are all did not even see the date because they are admitted facts. Second point is that the charge sheet is filed on 16/9/2020.
Yes.
That is also 5 years ago. However, they seem to make an annual ritual of filing supplementary charge sheets almost every year. So 21 has one, 22 has one, etc. Of course, but it's a larger issue. Lordship should decide sometime that by the expedient of filing supplementary charge sheet, you cannot generate an indefinite ongoing investigation. But anyway, so this is point number 2. So even charge sheets are very old. Now the charge sheets in the list of dates, Lordship will tick if Lordship wants to. Item 2 is my arrest. Item 3 is the real charge sheet. And then the other charge sheets are item is on 24/11/2020.
Which serial number?
Well, those are not listed by me. So the main one is listed. That is item number 3. The Lordship will just note on the side. The other 3 supplementaries are in November 20, February 21, and March 22. I'm sure there are ongoing more charge sheets also. And the last is June 23. Now, the list of dates is important from what I'm saying now. Just see that after the matter travelled back to the High Court, because delay now been held by Lordships in even very, very, very stringent acts to be a fatal flaw in the prosecution side. Look at the extraordinary delay from list of date number 11. Come to 11. Now, this is, I'm cutting the previous 2 years off, 3 years off. This is after the Supreme Court says that the other accused, which include me, my name is Gulfish Ahmed, are entitled and a liberty to seek bail on parity. Right, Bulus? This is as late as 2nd of May 23, item 11. Item 12 I apply for parity, and I want to make a point of this with great respect. No order is passed in item 12, comes in the High Court. In item 13, it doesn't get heard because there is a transfer to Manipur. In item 14, it comes before a newly constituted bench. In item 15, it is concluded arguments before the other division bench in March 24. Judgment is not reserved and is directed to be listed connected matters. This is how well as dates get prolonged endlessly. In item 15, this happens. In item 16, it is released from the bench after 6 months or 5 months. We're talking of bail here. Already after 3 years delay of incarceration prior to that. Then, 17, the trial court records the submission that the investigation is complete where all the charge sheet matter is right for arguments on charge. And 20 comes the impugned order in 2025 September. You should have this overall perspective of the dates. So this is my third point, the inordinate delay or even consideration. My fourth respectful submission is,
Which are the first two? The
the
fourth,
first is, I am
one
under
is you
arrest.
said inordinate delay.
No, first is arrest from 5 years. 5 years, 5 months. I'm already under arrest. I've already served time for 5 years, 5 months. More now. That was when the matter first came. Second is all manner of charge sheets have been filed. From 2020 to 23, 5 or 6 charge sheets. This is supposed to be a freezing of the whole case. Number 3, from even after your lordship's, if I may say, grant of liberty, 2.5 years have passed. Your lordship said so in 23. LOD 10. Sorry, 11. This date's 11. Fourth point is, I am instructed that I am the only woman in custody now. The only one. All have got 3 or 4 others have got. Now, Willis, just turn to the 5th point, which is on your lordship's page 3, where the dates end. Justice Anjari has got page 3 where the dates are ending. Now, Willis, see 1.1. I mean, how long can you, Willis, what is the point? I mean, if you get bail after 6, 7, 8 years, what is the purpose served in a trial? Charges have not yet been framed and arguments on charge are ongoing. I completed arguments in March 25. 8 co-accused concluded. 10 accused remaining.
When it commenced?
Arguments, please.
Argument.
Actual
ABC.
arguments commenced
Argument before charge.
on charge. That's
October
I-
2024.
October. My land friends are there.
October 20.
So really, your lordship is right. Your lordship will count the date from there. Although my arguments are over in March 25. Now we will see the nature of witnesses and documents is 1.2. 800 at a conservative estimate. Page is given. The item 1.2, para number 1.2, my lord.
Yes. Total site.
800 is a conservative estimate. Page 15 has it. Cited witnesses are 939. Supplement, I have broken it up into charge sheets. There is a distortion of the criminal justice system. I say with greatest respect. Merits don't matter in this. I'll come to the merit because I will satisfy my lord's conscience. But merits don't matter.
Are there any protected witnesses?
Yes, yes.
How many?
140.
140.
148.
100?
48. The concept of liberty is you put me on stringent conditions. Where will I run? What will I do? But you don't keep me in jail because you have 140 protected witnesses and 900 other witnesses. That can't be criminal justice of any kind. Now kindly come to item 1.3.
Yes.
I am citing deliberately Najib. Case my lord knows well. Why I am citing it is a UAPA case. And the para 17, I'll read only 1 or 2 of them later, but just note this.
Yes.
On delay in a UAPA. Next I am citing Javed Sheikh. Section. Sure. Then, Willis, the normal principle of Jalaluddin Khan, bail is the rule. This sounds very empty with great respect. This sounds very empty and rhetorical and hollow. This has to be implemented, it has to be operationalized. Now, Willis, on delay alone, Javed has this para in 1.6. This is irrespective of any merits. When a trial is prolonged, not open to oppose bail on the ground that the charges are very serious and bail cannot be denied on this ground, though there is no end to trial in sight. Then I am skipping the general law of 1.7, which now sounds very mechanical, but it's still important. It traces itself to Article 21, Hussain Khatun onwards. Whereas at para 147 of the impugned order, in para 1.9, I quoted with great respect. This is ironical. It would be an inversion. It would be something like Kafka. Inversion. I am being benefited is what the High Court is saying. I am paraphrasing. The High Court is saying you are being benefited. They harm me, therefore I must be kept in jail. That's para 147 of the judgment.
Yes.
Javed Sheikh, you should note, I have not put it there by mistake. You checked it? Yes. It's also UAPA. You should write on the side. These are UAPA cases. It's somewhat cruel to be told that you will be hurt, your trial will be hurt if you are hurried. Then you should counterbalance it by releasing. Then, the bail application alone in para 2.1, this is bail application alone, has been kept pending for 3 years and 4 months. But this is a star case. I don't think these facts apply to any other case. I mean, this batch is a star case. Your Lordship may dismiss my bail, Your Lordship may allow my bail, Your Lordship will keep my bail pending for 3 years, 4 months. I don't know what Your Lordship is issued on the other court directions, Jharkhand High Court, with 6 months delays. Now just see the next date. Ironically, after that order of the Supreme Court, at least 20 judgments on bail came. Now, after 2022, it is listed 90 times, 90, in para 2.2. Re-notified, separate division benches, etc., etc. Your Lordship's intent by the order of 11th of November was very different. It is carried out much, much later. Well, it's 2.6 cites Vitthal Vahile. An obvious point, but my Lord repeats it all the time. This repetition is in 2024. My para 2.6. Deprives me of 21. Then my Lord repeats it on the speedy disposal. Very strong word. Because both with Tulsiram and Arjun Katar in 2.7 are given the paras.
Yes.
And ultimately, my Lord has put 1 month in the 2022 judgment of Until. It sounds unreal.
All.
Then, just a few minutes more and I'm done. I want to deal with 2 more points and I'm done. Whereas on the parity issue, para 3, just note this. I don't want to talk about anybody else. I'm an A for sure case. I'm a young, just out of college or MBA student. Your Lordship has upheld Kalita and Narwal in my first para 3.1.
Yes.
I hope I'm not showing the pages, but they're all there. So your Lordship can take it as factual because it saves time, otherwise we will not be able to finish at the time given to us. Now, allegations are, this is important, 3.2, that we are part of a Pijra-toed a group of female students and of the WhatsApp group warriors. And we organize protests in so and so places, Silampur and Madina Masjid, etc. Next page, page 5, has the other 3 allegations, secret meeting, etc. This word secret is very interesting. I'll just show in a minute. Open meeting held in open broad daylight. What is secret about it? I don't know. Now, the first point in 3.3 is that these are allegations 95% against Devangana and Natasha, who have got bail, not against me. I hope my Lord has got that marked.
Yes.
Not against me at all. Again, the High Court deals with it in one line in para 330, in my para 3.5. Role ascribed to petitioner distinct from co-accused. Malas, what did I do which makes out an offense is described in para 4.1. I set up protest sites. No allegation, photograph, movie, anything about violence wherever I was present or my sites. Now, I attended the so-called meeting at Silampur. Well, what is attributed to anybody? These are people who have got a bail, the Silampur meeting people. So I attended a meeting, so what? Did I do an act of violence? Did I insurrect? Did I get up and say you throw a bomb, throw a pistol? Then 4.4 is allegation, which is very strange, of exhorting people to use and hold chili powder, acid bottles and dandas. These are the protected witness names given, Delta, Gamma, Echo. My lords asked those things. No documentary or oral evidence of use of these objects at any protest site associated with me. Well, something has to be there. If everybody is carrying chili powder and acid bottle and dandas. No, this postmortem, this medical report, MLC. Next point. None. No seizures. Some should be there at least. The second allegation is a conspiratorial meeting at Chandbar. Again, not a single incriminating word or act. In fact, normally for all these sedition and lordship wants an overt act. Here, not even words or act associated with me.
Yes.
Now, there is an, I'm just finishing in about 5 minutes.
Yes.
There is an allegation by this Tahir, getting money from Tahir Hussain, which one was this they get money received from Tahir Hussain becomes terror funding. Now let us see this. How much money, when, and how given by Tahir to me, nothing is stated. And if it is so much, 5.5 years, we will keep on saying this. Let us assume this is allegation in trial will be made. 5.5 years are behind. Next, is there a test identification parade? I have no connection with Tahir Hussain. You have to do something to connect me. Tahir Hussain may have given money to so many people. Something has to connect me. I have not received, I have not shown to receive, I don't know the man, I have not dealt with him. Now, 5.2. The finding is that I created the WhatsApp group and that shows my involvement. It is no doubt true that I created a group to lobby. But your lordship's legal test is incite violence, rioting, communal disharmony. They react to the word orthon ka inqilab. And many of these, in fact, most of them are not even placed on record. Well, just 1 minute more, one important point again. A short 2-page I've made on the counter has come yesterday. Obviously, we can't find a result. I've just made a table. Give me one copy. Give me one copy of this. This is pinpointing what they said yesterday. Principal allegations in the counter is that I have delayed the trial.
Yes.
Just spend a few minutes on this 2-page. Now, first point, in other FIRs, I've got bail, mainly related to Japrabad. The first line. My lord has got that?
Yes.
I am not a member of Pinjara Code. And if I am a member, then these two persons, ladies who are members, have got bail on parity. That's the second sentence. First, I'm not a member. You not show anything. Secondly, if I'm a member on parity, they were the leaders, allegedly. Now, there is not an iota of actual evidence regarding use of red chili powder, bottles and acid, no recovery, no malicious proximity with me of any kind. Now come to the charge. Delay in the framing of charge is attributable to me. This is very outlandish. This is very sad. I've come to Supreme Court. I've taken 5.5 years because I'm dealing my own trial. I can't get out. Just see this. I am the third accused to argue in charge. I concluded in March. How can I delay if I concluded in March? From 23 September, which I believe Mr. Agarwal said October or September, whatever it is, till November 24, it is for 1 year squarely attributable to the prosecution to refuse to explain whether the investigation charge sheet was completed or not. Request was made for handing over charge sheet. This did not delay the proceeding in any way. I can ask for documents. Then second allegation is I'm a member of Pinjara Code. I've answered the appointment. No evidence on record that I'm a member. At the highest, I participated in anti-CA protest. All the associations participated together. But Natasha and Devangana are the main alleged leaders, admittedly of Pinjara Code. They are out on bail since June 2021. June 2021.
All right.
Then all protest sites. Just see this item 5. Where is the evidence on the right side? Item 5. Some evidence for this. Recovery, proximity, house, in my hand, on photographs.
Yes.
Because I would say that it's just 1 or 2 paras your lordship may see the judgments, or your lordship may take it as, because these 2 judgments are important. One is the judgment in Najib, take out Najib, 2021, 3 SCC 713. I'll limit myself to reading only 1 para.
Para 17.
Yes. Yes. Compilation. This is page 140 of the compilation. Come on, hurry up. Because I'm giving. I want to do it quickly. Give a copy to them also. I will straight away take it to verse 70. Oh, sorry, 17, page 140. These are UAPA cases, so also is Javed.
Page number?
Well, it's just the relevant part. One 140. May I read 17?
Yes.
140 just Anjari as well.
Yes.
It is thus clear to us that the presence of statutory restrictions like 43D5, etc. of the UAPA per se does not oust the ability of the constitutional courts to grant bail on grounds of violation of Part 3. Indeed, both the restrictions under the statute as well as the powers exercised under constitutional jurisdiction can be well harmonized. Whereas at commencement of proceedings, the courts are expected to appreciate the legislative policy against grant bail, but the reverse of such provisions will melt down when there is no likelihood of trial being completed within a reasonable time, and the period of incarceration already undergone has exceeded a substantial part of the prescribed sentence. Such an approach would safeguard the possibility of provisions like so-and-so being used as sole metric for denial of bail or for the whole-scale breach. Whereas just also see Javed, which is in the same compilation at page 209. This is also UAPA.
Which paragraph?
Relevant part is at 212, para 7. 212, para 7. That's it.
Sure.
Having regard to the aforesaid, we wonder by what period of time the trial will ultimately conclude. However serious a crime may be, an accused has a right to a speedy trial as enshrined in the Constitution of India. Over a period of time, the trial courts, the high courts have forgotten a very well settled principle that bail is not to be withheld as a punishment. Well, as the Lordship will keep one thing in mind. I am the only female in this whole batch. Not that females are entitled to anything special. Today, Malas, with these facts, I am held, Malas, under 437 CRPC. There is, Malas, some presumption Lordship gives about females. I already have bail in 2 other FIRs, so-called Jafrabad. In conclusion, I would say this, Malas. In none of the cases which are reported by Lordships and cited by us, would your Lordship find, I can't think of any case, maybe there may be 1 or 2, I don't know, 5.5 years. These dates of delay. Assume that there is a serious act. In what way can you balance the real issues balancing today the interest of justice and of prosecution?
Oh.
Ultimately, if your Lordship finds that it is extreme, then your Lordship really can control it fully by the triple test. Where will I go to the frightened witnesses? Where will I travel abroad without a passport? Where will I not cooperate after 7 charge sheets? What is left there to cooperate with us after 6 charge sheets? So, why should justice not be balanced with the demands of liberty for a person who's 5.5 years? And what is my age? 32. I'm a student. Very high degrees I was doing. So I'm not a hardened criminal who's going around murdering people if I'm let out. Deeply obliged. We have a rejoinder. I just tried to compress it, but we have.
But can your Lordship take up 10.3?
Between you two, who is elder?
I'm sorry?
Between you two,
That's
you
a
and
compliment to him, not a compliment to
by,
me.
by seniority, who is senior?
Of course,
No, Manas, he is senior.
he's
It makes no
much
difference.
senior.
It makes no difference.
No, the reason is,
Whereas we-
we were looking into the Advocates Act.
No,
Then
it's okay.
senior amongst the senior will be the first,
It
right
doesn't-
up.
it doesn't matter. I never look at these things. It's not relevant.
No, it's a matter of your convenience.
This question was a great compliment to him, and not so much of a compliment to me.
Normally when batch of seniors are there, the senior most of the senior will lead.
I was the
Normally
age
that's
father.
not anyway. Many things.
To
we
make that statement, we wanted to be sure. So we read the
don't-
Advocates Act.
Many of our traditions we don't follow anymore, but it's okay. We abide by it. But it's just take.
Always your statements are loaded. We like to say it.
As they should be. Just hand over this 56 pictures on this page. Please hand over. Manas, my learned friend dealt with the hearings in the High Court, but I want to show you what happened in the trial court. Because, Manas, as your Lordship knows, procedure is at the heart of liberty. Substantive law is one thing, but procedure is at the heart of liberty. That's why it says procedure established by law. Now, Manas, kindly see. What has happened in the trial court? 55 dates of hearing of both the main matter and miscellaneous applications. Learned presiding officer was on leave for various reasons, including medical grounds and attending judicial training programs. Well, then, on 11 dates of hearing of both the main matter, on 11 dates of hearing on both the main matter and miscellaneous applications, the matter could not be taken up due to issues such as shortage of staff, personal assistant, ailment, and assistant ailment stenographer, and other such administrative and logistical exigencies. On 26 dates of hearing of largely miscellaneous applications, the matter could not be taken up due to heavy workload and paucity of time. Often the court was already engaged in hearing of both matters, as also the present matter was required to be adjourned due to lengthy argument, judicial work relating to the present case itself. The next is, Manas, very shocking. On 59 dates of hearing of both the main matter and miscellaneous applications, the matter could not be heard due to the unavailability of learned SPP.
That friend has given me a wrong note. It's
Sorry,
not the note which you're reading.
Learned SPP on various grounds. 59 dates, they sought adjournment. on ill health, personal emergency, busy in another court, busy in high court and bail matters, internet connectivity issues, no unavailability of assisting police officers. Another reason for adjournment on such dates is as if the prosecution sought time to file reply written submission. On 4 dates of hearing in 2025 onwards, no hearing took place on charge due to lawyers' strike. Now, Miller, dates concerning arguments on charge. Now we come to the arguments on charge. The arguments began on 10/9. Learned counsel for Umar Khalid argued the charge on 7 days. Matter has been adjourned 6 times on 22/8, the date of which arguments on behalf of Umar were to begin, twice on account of lawyer strike, once as counsel for Umar Khalid requested to begin arguments on VC and the request was declined, twice on account of counsel for Umar due to a conflict with another hearing, and once on account of learning presiding officer. So, Madam, in their counter, they say that I have been taking time and delaying the proceedings. I just wanted to record that. Now, Madam, the next note. I won't take long notes. Just give it. Just don't. Now, Madam, the charge against me is conspiracy. Only conspiracy.
You're, Sibal, you're appearing for?
Umar Khalid. Charge appearing is conspiracy.
10.3.
And let's just note there are 10.3, I'm saying. I said 10.3. There are 751 FIRs. I'm charged in 1. If it's a conspiracy, Madad, it's a bit surprising, no, Madad? If I am the responsible for the riots. Now, just I'll quickly go through this. Petitioner was not present in Northeast Delhi from 22/2 and 25/2. The petitioner was not even in Delhi between 23/2 and 27/2. So on the dates when the riots took place, I was not in Delhi. Admittedly. No recoveries, weapons, arms, ammunition, acid, funds, or any other incriminating materials whatsoever have been made from the petitioner or at his instance. No physical evidence has been retrieved from the petitioner which connects the petitioner to any violence or writing. If I'm not there, how can I be connected? Not a single witness has given any statement that connects the petitioner to any actual incident of violence that ensued in Northeast Delhi. No allegations of the petitioner having procured, received, raised any funds for a terrorist attack. Importantly, no recoveries of any funds have been made from the petitioner or at his instance. 751 FIRs were registered in relation to the alleged incidents of 22/2 to 26/2. However, the prosecution has not relied on a single recovery or witness statement in any of the said FIRs to connect the petitioner to actual violence. Apart from the present FIR, the petitioner was only arraigned in one other FIR out of the said 751, being FIR 101 at Khajuri Khas, which dealt with a purported incident of violence on 25/2 in Khajuri Khas. Petitioner was granted bail in the said FIR while order dated that and was subsequently discharged by order dated 3/12/2022.
Yes.
Only overt act alleged against the petitioner is a speech delivered by the petitioner in Amravati on Maharashtra on 17/2. The riots took place, your lordship knows, from 23/2 onwards. I gave a speech on 17/2, and that is the basis on which they allege that I am the responsible for all this. And in that speech, I've said nothing. It's a public speech that I made, I've said nothing about any acts of violence or that any riots or that instigating people. A bare perusal of the speech which invokes Gandhian principles of non-violence and makes reference to the Constitution of India makes it unequivocal, clear that the same cannot be considered provocative by any stretch of imagination. Further, the same cannot come under the ambit of vague, overboard, an ambiguous phrase by any other means of whatever nature under Section 15. Now, this is important. Let us kindly just have a look at Section 15 for a minute. Not arguing merits, but I just want to show the definition of a terrorist act. Hello, Justice, may I have it? Should be page 12 of your book, hopefully it's the same. Lordship has 15? whoever does any act with intent or threaten or likely to threaten the unity, integrity, security, economic security, sovereignty of India, or with intent to strike terror or likely to strike terror in the people of any section of the people or in any foreign country. Now, say, by using bombs. Admittedly, I've never done that. Death due to injuries, no allegation. Loss of damage or destruction of property, not responsible for any of that. Disruption of supplies to services, I'm not responsible for any of that. The charge is conspiracy, but I just point that out. Damage to monetary stability of India doesn't apply. Damage to destruction of property in India doesn't apply to me. Overalls by means of criminal force or show of criminal force or attempts to do so or cause of death any public functionary doesn't apply. Detains, kidnaps, or abducts any person doesn't apply. What applies according to them is the last part, or any other person to do or abstain from doing any act. This is what they say applies. Nothing specific.
All.
So, whereas I am not involved in the offense at all. And I'm there now for 5 years anyway. I just wanted to point that out. So it should be read as justum generis is my solution. Then, Mullahs, now regular bail was granted to 3 accused Mullahs. In the note, there are only 2 mentioned, Mullahs, the 2 ladies, Devangana and Natasha. But there was a gentleman, Mullahs, Asif Iqbal Tanha, accused 1, who was also granted bail. And this court upheld it. Asif Iqbal Tanha. Now, Mullahs, in the SSB filed by the prosecution, at the time of admission, notice was issued and it was said, granted bail, this should not be treated as a precedent. Then an application was filed. And then the court clarified it, namely that if the co-accused is entitled to a plea on parity, that is for him to make and the court to consider. So I was entitled to a plea of parity. Now, I am not present in Delhi on those days. Now, these 3 have got bail. And they were present. Not that I have anything against them. They were present and I am denied bail. Same witnesses cited against me, same witnesses cited against them. Same evidence against me, same evidence against them on protected witnesses, 47 of them. 100 are public witnesses, 47 are protected witnesses. The High Court dismissed the petitioner's argument on parity by distinguishing the case against the co-accused and observing that the petitioner's role is prima facie grave in the entire conspiracy, having delivered inflammatory speeches on communal lines with that only inflammatory speech is 17th of February. I have never delivered any other speech, not one, and that speech is not inflammatory. It's available on YouTube, Mullahs. High Court ended much as the prosecution has contended that co-accused have also delivered purportedly preferred Mullahs. We are not concerned with co-accused Mullahs. I have never delivered any inflammatory speech. Then Mullahs, facts. Arrested in 2020, 13 September over the page Mullahs. Spent 5 years, 1 month, 18 days. 18 accused to be tried together. 900 witnesses. Not a single witness examined so far. Stage of framing of charge. 3,000 pages of charge sheet and 30,000 pages otherwise. And after filing charge sheet, 4 supplementary charge sheets filed, which my learned friend has mentioned. Charges have not been framed yet, fine. Arguments and charge are going on, and the petitioner is, leave that up. Now, let's just kindly see, my learned friend has pointed out 3 judgments. I'll give you a compilation of those judgments. Give a compilation. Yes, give a compilation. What I've done is, for each judgment under UAPA, the term that the persons were under arrest and the bail granted, the pages and the paragraphs are mentioned.
These judgments.
Now just see, Mullahs. Najib, 5 years, 276 witnesses, 3-judge bench, bail granted. 3-judge bench, bail. Sorry, I'm sorry. Yes.
Index.
Index. No, just see the index. Yeah.
Yes.
So I was mentioning Najib, 3-judge bench, 5 years, 276 witnesses left. Charges already framed on 27/11/2020.
No, what do you mean by left?
I'm sorry?
Middle of
Unexamined.
Unexamined.
middle of a trial.
Middle of a trial.
No, totally, how many witnesses were there in this?
I'll just check.
We'll check.
We'll check and inform.
We'll check with informers, but there were too many 270s were left. 551. Just check. Then Tawa Fasal, 570 days, 92 witnesses, UAPA Millers. Charges not framed. Then Jahir Haq, 8 years, 103 witnesses left. Ravi Prakash, 3.5 years. Even in 3.5 years, bail was granted. 18 witnesses left. Means in the midst of trial with 3 years in incarceration, bail was granted. Then Millers, Muslim Alias, 7 years, 4 months, 9.5 years. Then Sheikh, my learned friend, is cited. Millers, 4 years, 80 witnesses, charges not framed. Javed Iqbal, 9 years. Salam, 4 years, 2 months. Angela Harish, 5 years. So, Millers, all the judgments and all the paragraphs, I don't want to take the time of the court. Millers, they're all set out here. Just
the seriousness.
And whereas the court has said the seriousness of the offense is not relevant for the purposes of bail when he has been incarcerated for X number of years. That's what it says. If the state or any prosecuting
59.
agency,
Page 59.
page 59 of this, including the court concerned, has no wherewithal to provide or protect the fundamental right of an accused to have a speedy trial, which is the procedure part which I was mentioning. Procedure is at the heart of liberty, right? As enshrined in 21, then the state or any other prosecuting agency should not oppose the plea of bail. That's para 17 at 59, on the ground that the crime committed is serious. Article 21 applies irrespective of the nature of the crime. And we may hasten to add that the petitioner is still an accused, not a convict. That's the next paragraph. The overarching postulate of criminal jurisprudence that an accused is presumed to be innocent until proven guilty cannot be brushed aside lightly, howsoever stringent the penal law may be. So, that's the heart of it, man. And what is that on the law? Anything else?
The last judgment, sir.
The last judgment, Karnataka judgment, I just point out where that.
So the last page.
The last page of this paper, of this compilation. Justice Sundaresh.
Yes, Justice Sundaresh.
Yeah. It's page 173, one page before. Yes, 171. Well, 171 of this very compilation. This is this month, brothers. 7th October 2025.
Blast in Karnataka.
The blast in Karnataka. We've heard learned counsel appearing for appellants and counsel appearing for respondent. Appellants have been arraigned as accused for offences punishable under such and such. And under UAPA and Section 2 of the Prevention of Destruction of Property. I mean, here I'm not involved in any of that. We've pursued the charges framed. Appellants have been under incarceration for more than 5 years. There are 254 witnesses to be examined. Appellants are amongst two amongst 138 accused persons. Taking note of the aforesaid facts, we have no hesitation in setting aside the impugned order and grant bail.
Oh.
So that's I'm not going to merits purposely, because otherwise deeply obliged.
May it please, Milord. I beg to appear in 10.1, Milords, on behalf of Sharjeel Imam. Milords, there's one aspect. The prosecution took 3 years entirely, Milords, to investigate this matter. 3 years. That means the FIR, Milords, which is registered on 6/3/2020, first charge sheet filed, Milords, on 16/9/2020. Give that this thing, Milords, instead of. And the last supplementary comes to be filed, Milords.
We're appearing for whom?
Sharjeel Imam 10.1.
Sharjeel Imam.
Sharjeel Imam. So, my lords, the FIR 6/3/2020, first charge sheet is 16/9/2020, and the last supplementary charge sheet, it doesn't mention the date of the FIR, but where it says main charge sheet, my lords, lordships may only make a note that 6/3/2020 is the date of the FIR. And where it says 7/6/2023 is the last fourth supplementary charge sheet that comes to be filed. So please see the dates, 3 years in investigation. So there was no occasion for the trial to progress for those 3 years in any case, my lords, because the prosecution was saying that we are still investigating the case. So out of the 5 years or whatever is the delay that has been mentioned, my lords, by Mr. Sibal and Dr. Singhvi, 3 years goes in investigation alone. For me, I am arrested, my lords, in this FIR on 25/8/2020. And the first supplementary charge sheet is where I am named, which is 22/11/2020. So 25/8/2020 is my arrest. And the first
25/8 is it?
Yes, my lords. 25/8/2020. And the first supplementary charge sheet where I am named, my lords, is 22/11/2020. So from 22/11/2020 till 2023, in any case, I'm awaiting trial, which cannot progress. So 3 years gone straight away. Out of which, my lords, after that, there was some confusion in the court, in the trial court, whether prosecution has completed investigation or not completed investigation. That your lordships will find, my lords, and then against over the page, my lords, 18/9/2023, the list of dates, my lords, which mentions 18/9/2023, accused persons, my lords, sought to know from the prosecution whether prosecution has completed investigation, which comes to be recorded by the trial court, my lords, on 4/9 over the page, my lords, 4/9 in bold, 4/9/2024. 4/9/2024 is when, that means, my lords, a year ago only, where the trial court notes, my lords, that the investigation is complete. In bold, it is written, my lord, learned trial court observed that the prosecution in its written submissions has stated that the investigation is complete in respect of all accused persons, and therefore the learned court can commence the hearing arguments on charge. So that means, my lords, till 2024, now from 3 years to now 4th year, I'm in custody because 167 has been complied with. First supplementary charge sheet is filed for me, but I'm languishing in jail as far as that is concerned. And till 2024, my lord, that September 24 is when clarity comes for the first time, that is only a year ago, that prosecution has completed its investigation. And therefore, we can begin as far as the trial is concerned. Then comes that 1 year, my lords, because there are so many, and I have set out, my lords, here over the page on the arguments on charges, number of accused persons who are there. Everyone will address on charge, my lords. If there are so many accused persons, they will address. Some compliance of 207, whether done, some electronic evidence, all these things. Voluminous. It has almost, my lords, as many as 900 witnesses and tens and thousands of pages for 207 compliance. This I am saying to rebut, my lords, the what is said in the counter affidavit. The delay is on our part. There is no delay till 2024 on our part, my lords. I have explained that to your lordships, my lords, in my respectful submission. Now, on the merits, my lords, please consider this. I was already in custody in another FIR, which is registered, my lords, on 25/1/2020, which is FIR number 22 of 2020.
Where have you said so?
Yes, my lords, here. Here, it's at page M, my lords, of this. In another chart, but here also
This list of dates.
This here, my lords.
Additional list of dates.
Yes, additional, my lords. It keeps getting added, my lords, and causing confusion. I'm sorry, my lords, for that. And I'm not the last, my lord. I'm sure those who follow me will be also giving. I apologize for this.
Mr. Dave is in advance ruling, apologizing on my behalf.
Yes. Now, my lords, that he was a student, etc., all that is the introductory part, my lords. Please see what is underlined: period of custody, enormity of evidence, and stage of trial. Now, 1. Petitioner is in continuous custody for almost 5 years, 9 months. If we take into account FIR 22, where I was arrested on 25th of January 2020. So in FIR 22 of 2020, I was arrested on 25th of January 2020. So therein, the total period that I have been in custody in these cases of speeches is almost 5 years, 9 months. If we have to include only for this particular FIR, my lords, it's about 5 years and 2 months. So when I was already in custody in the earlier FIR, because I had given speeches in December and in January, I was picked up soon after that in FIR 20 of 20 or 22 of 2020. The present FIR, as your lordships noticed, my lords, is of March 6/3/2020. So for a good period of 2 months, I'm already in custody of the police. When this 6/3 FIR is registered, which is 59 of 2020, originally I'm not named in it. Only Umar Khalid is named in it.
No, Umar does not work.
In the FIR.
In the FIR, named in the FIR. And while the riots which are supposed to have happened, I am already in custody for them. When the riots are taking place in February, I'm already in police custody. Also, my lords, I want to stress on this part, I am not an accused in a single one of those riot cases. Not a single one of those riot cases. With 120B or 34 or anything. I am only accused of having given inflammatory speeches. Now, pursuant to those inflammatory speeches which were given in Delhi, Aligarh, Asansol, and Gaya, my lords, I am on bail in rest of the other cases, my lords, including this FIR 22 of 2020. So if FIR 22 of 2020, where I got bail after being in custody for 4.5 years,
Except you're on bail in all cases except FIR number
59 of 2020, which is the present case, which is the conspiracy as well.
Oh.
So as far as my speeches are concerned, which is what they have said has led to these riots. I don't know how many they couldn't have, because my speeches are in December and January, riots are in February. I'm already in custody. I'm in custody since January onwards, my lords. And therefore, for the speeches part, which is I'm concerned, which is attributable to me, I'm on bail in all others. This is the only one which remains, my lords, as far as my role is concerned. Now, my role comes, my lords, as far as your lordships may only see. I have mentioned this part, my lords, over the page for reasons of dismissal of the impugned order. Please see, my lords, reasons for dismissal in the impugned order is that I was the first of the block to act against CAB. And I distributed pamphlets. All right, my lords. All initial planning done by petitioner, that is creation of group, conceptualizing and incitement. Giving of inflammatory speeches, circulation of pamphlets point towards conspiracy. Role of petitioner grave because he delivered speeches to instigate mass mobilization of Muslims. And hurried, it should be trial, my lords. Fifth, not trail, I'm sorry, my lords. Hurried trial would be detrimental to both accused and prosecution, which Dr. Singhvi has argued, my lords. I'm not repeating for it. Now, my lords, please see my role physically, if I could have played a role, if I'm in custody from 28th of January to the riots which take place in 20th to 23rd of February, my lords, any role that could have been done. I wouldn't have access to my phone or WhatsApp group that I have alleged to have created, or any of the meeting any of the persons. Physically, I'm not present there. So, my lords, as far as I am concerned, if they've not charged me in any of those riots that have taken place, at best it can be for giving of some inflammatory speech on parity with the bail orders that I've got in other bail matters for giving of the speeches, my lords. I would be entitled to bail, and even in this case, my lords, in 59, this is the last remaining of the cases, out of which 5 years, 2 months that I've undergone, and the delay is considerable as far as what has been said to your lordships, my lords, submitted to your lordships. Now, there's only one other part, my lords, my grounds I've mentioned there, that there are no overt acts. Of course, there can't be any overt act because I'm in custody. Two is that the sole basis of my implication is the chats that are recovered in FIR 22, in which I'm on bail. So how many prosecutions, my lords, with respect, am I going to face for the speeches that are there? There are FIRs registered in Nagaland. There are FIRs in Manipur, which details, my lords, I have mentioned at page M of my paper book, as far as the number of FIRs that have been given and in which charge sheets.
What is the nature of speech? You get
Because the nature of speech,
purported.
because this, I called for that there should be, there's a word in Hindi called chakka jam. Chakka jam means that to bring the blockade or standstill, the wheel.
What is it called?
Chakka. Chakka is a wheel, my lords.
Okay.
And jam, my lords, in the jam is there is a jam, there's a blockade. There's a for protest against the bill that was going to be introduced, my lords, of CAA, that I called upon people that protest against this bill. That is what it was. And pursuant to which speeches were given, pursuant to which FIRs were registered all over the country against me for those speeches, and pursuant to which I have been granted bail in all those for those speeches. Now, to link my lords, the only thing is that to link my role in the riots that took place, my lords, was a bit of a stretch. My speeches are at a particular time, 2 months almost before. It couldn't have been foreseen that riots would take place 2 months hence on this particular day. There's no planning that I have said that on 20th of February 2020, you please go there and have the riots as far as these things are concerned. I couldn't have done it. I'm in custody, my lords. I'm sorry for the repetition, but I couldn't have done it. And that is the nature of the speeches. But please see this page M in my paper book, my lords. I have set out the FIRs that are there against me. At page N of the paper book, page M and N, just please make a note. And there are not only here, I've got bail by Allahabad High Court for the UP speech, and that was given in Aligarh. I have got bail, my lords, default bail, in fact, in Arunachal Pradesh. All over the country, this was done, as far as my speeches are concerned. Not only this. And
you are residing where? You are resident of
Bihar, my lords. Of Bihar, but I was studying in JNU. I was studying in JNU. I was a PhD student in JNU. That part your lordships may get at the first, in the first part, my lords, on the petitioner is a final year PhD student, a research scholar in JNU. He has completed his BTech, MTech from IIT Mumbai, also masters in modern history and masters of philosophy from JNU. He is
a permanent resident of.
Otherwise, a permanent resident of Bihar, my lords.
Bihar where?
Jehanabad, from where I was arrested in the other FIR, which is 22 of 2020. And the lords, if your lordships are to see the speeches, I abhor violence in those speeches. I do not say I do not advocate violence. I don't say, I say protest, as is our right, my lords, as a citizen in this country to protest against something in a peaceful manner, which is recognized by the Constitution itself, my lords. But my lords, for the extreme part, my lords, to rope me in now with this FIR, and this is the only remaining FIR, my lords, given the period of custody that I have got, and the stretch with which I am sought to be implicated for the riots that took place, my respectful submission that if I'm given bail, pursuant to, since I'll be already in bail, namely that parent FIR, which is FIR 22 of 2020, from where the materials were all collected, etc., of the speech that took place. That is a respectful submission. I'm not repeating the arguments on delay, etc. That is there.
One second. Pre-lunch don't make such. You know what is lawyer's time is 5 minutes.
And every
As far as possible, restrict it to 1 hour. Reason is we have some more matters.
yeah,
So, and also my brother is having one special
let
day.
it be on Monday or Tuesday.
Monday. We will
Tuesday.
continue on Monday, first hour. At 10:30.
First hour.
At
Yes.
10:30.
First item.
If I
As
read the
first
counter, half the work will be done. My lords may read by counter, half the work will be done. It will be easier for
397 pages.
Monday, first matter.
May I request Tuesday, only one day.
No, Tuesday we are. Monday, it will be fresh so that it can be done. Raju, make some accommodation.
Monday the miscellaneously heavy.
That is why.
I have to go about.
No,
They will agree with you not one.
no,
I'm not agreeing with you.
Raju, including this court, nobody will say for a request for a passport, so far as the
That's
Attorney General or Solicitor General or Additional Solicitor General. Normally we don't. Normally.
May I request in that case fixed time at 12 o'clock on instead of.
No, let them, you ask your colleagues so that you attend 1 hour. I think these three will take about lawyers 5 minutes, will into 5 minutes. So, you ask your colleague to be here. After that, if still you require accommodation, half an hour, 1 hour, will definitely will accommodate.
Because that calculation came when your lordships were this side, from that experience, not from that experience.
No, from the present lot.
We have done all those things.
That's why I'm saying.
Always, there's already an implicit acquiescence in 5 minutes being more than 5 minutes. But we'll try to make it as short.
If they want to circulate any note, then we give it to us in advance.
All it, that would be most appropriate. Whatever
We'll do
notes you
that.
have
We'll
got,
do that.
we'll do that. All right. The learned senior advocates, Abhishek Manu Singhvi, Shri Kapil Sibal, and Shri Siddharth Dave. For further hearing, Monday. Top of the list. Even if it is not, you mention it at 10:30, after the mentioning is over, we'll take it.
Please, one more blind bullets. They have not annexed the charge sheet. Permission may be given for us to place the charge sheet by way of pen drive.
All right. You have already given it to them.
We have it right now.
I can give it right.
Right?
Landing it over right now. You already have recharged.
Yes. Thank you.
45.
Grateful.
Exactly.